Hello, and welcome to the first session of the DC Bar Pro Bono Center's four-part webinar series in partnership with Steptoe & Johnson, Protecting Your Innovation. This session covers the basics of intellectual property. I'm Christine Kulumani, staff attorney with the DC Bar Pro Bono Center's nonprofit and small business legal assistance programs. Thank you to my colleague, Lauren Paley, who's done all of the behind-the-scenes work to make today's webinar and this series possible. Also, a tremendous thank you to our presenters, Kate Kappert and Lee Guo, both of whom work at Steptoe. Before we get started, just a couple logistics for the webinar. First, if you're joining us live, the webinar will be recorded. To access the recording, please complete the survey that we will email to you. In addition, you have access to the presentation slides in your GoToWebinar control panel under Handouts. If you have questions as we go, please send them to us through the question box in the GoToWebinar control panel. We'll try to address questions today, but we may save some questions for the subject matter specific section to come. With the mechanics done, let's get down to business. Organizations and entrepreneurs may sometimes overlook their most valuable and important assets, intellectual property. Names, logos, recipes, technology, and devices can all be at the core of success and recognition for your brand. Understanding what can be protected, how to protect it, and how to enforce any applicable rights is critical. And with that, I'm going to hand it off to Kate to kick us off with the basics of intellectual property.
Hi, it's nice to meet everyone and to talk to everybody. As was said, we're going to be doing kind of an introduction to intellectual property today, going through kind of the different categories of intellectual property, and then in the next coming sessions, we'll do more of a deeper dive into the different categories. So today, again, is just going to kind of be more of a high-level overview, not getting into as much of the nitty-gritty, and we can kind of get into that in the coming weeks. Just kind of before we get started, and this is just a general disclaimer that we need to give. So Lee and I are both associates at Steptoe & Johnson. We're both in the DC office. While we are talking about legal issues, we're not giving legal advice during these seminars, and we're also speaking on our own personal behalf and are not representing any of the views, et cetera, of Steptoe. So in general, we're going to kind of go through a brief introduction of the different types of IP that we're going to cover, and then talk a little bit more and give a little bit more detail about some of the different categories. So we're going to cover copyrights, trade secrets, trademarks, and patents. And I'll talk about some of these and then hand it off to Lee, who will cover trademarks, some of the patents, and then we'll wrap up at the end. So in general, intellectual property is the creative product of the mind. You have intellectual property that falls into, we'll go with 4 different buckets for now, but something to think about is that not everything is necessarily cleanly in one bucket. So something may be able to be copyrightable or patentable or also a trademark. A specific device may be able to be protected in a lot of different ways as well. Trade secrets are kind of the one exception to that, and we'll talk about that as well. So as we talk about them, something to consider, and as you're considering what you need to protect, and as you're developing your business, your products, your written material, plays, etc., you need to consider all different types of intellectual property and make sure you don't necessarily pigeonhole yourself into thinking, oh, well, I only need a trademark, or this is only a copyright, or maybe this isn't really a patent. A lot of times, the different categories cover more than what you may think they do. So in general, copyrights, works of authorship, a lot of times people think of them as only being written works. That's not necessarily true. Movies, television shows, plays, music, things like that are all copyrightable. the one thing is that they do need to be recorded in some medium or form. So there has to be some sort of tangible form that they can be publicized in. Trade secrets, kind of as the name implies, are confidential. There's a little bit of mysticism and a lore about trade secrets. Kind of what do they cover, what don't they cover? In some ways, it's kind of a note when you see it, but we'll talk about what different trade secrets can be and what to think about as potential trade secrets as you're developing a business, and how to protect them to make sure that you don't accidentally or inadvertently disclose something that maybe you could have protected as a trade secret. Trademarks, general brands. So a lot of times people think about this, you see the TM logo or you see the R logo. Lee will talk a little bit more about what each of those means and how to protect your brand through trademarks. And then patents. So patents are typically thought of as inventions. There are different types of patents. So you have design patents, utility patents, and plant patents. They cover more than just technological products or technology. They can cover processes, manufacturing processes, methods of doing something, chemical formulations, things like that. And we'll give a high-level overview of some of that today, and then we'll do a deeper dive into patents and what the world of patents really entails. That's going to be the first kind of deeper dive in our next session. So something else to think about, and as I mentioned, products can include multiple different types of IP. So on this slide, you'll see there's a smartphone pictured. The smartphone itself has all of the different types of IP that we just talked about included in the phone. So for example, you have copyrights. So the software code, the code that's used to operate the phone is copyrightable. User manuals for the phone can be copywritten or can have copyrights. The ringtones that actually play when somebody calls you can have a copyright associated with them. So aspects of your phone can have copyrights. There's also trade secrets. So the confidential or technical or business information that relates to the phone. So for example, if there's a process or procedure that you use or that your business uses in developing the phone that isn't generally publicized, or if you have a list of customers that you don't keep public, that you maintain as confidential, that you use for a competitive advantage in the marketplace, those can be protected as trade secrets. Trademarks, so the name of the phone, the logo, everyone kind of has certain, when you think of, let's say for Apple, for example, you have the Apple icon in your mind, I'm sure, as I'm talking right now, and that is an example of the logo. So design patents. Design patents cover certain design features. If, for example, in the phone, there was litigation between Apple and Samsung related to design patents. Related to, for the example, in the older iPhones, you may recall there was the button for the home screen or rounded edges for a phone. All of those types of things can be protected with design patents. And there's also utility patents. So utility patents are the most common type of patent, and they cover the technical solutions, components of the phone. So maybe the semiconductors, other aspects of the phone itself, and also manufacturing methods or methods of doing certain operations with the phone or that are run on the phone or the phone's hardware or software. So we're going to start talking a little bit today about copyrights. So I think the third session we'll be talking more about copyrights and trademarks, but copyrights in general are original works of authorship. Again, this slide has some categories. It has 6 general categories that copyrights often fall into, but these categories are broader than you may actually think. So literary, the first thought that comes to mind when you hear literary is written work, book, magazine, articles, things like that, textbooks. Those are all things that can have copyrights, but this also includes, as I said before, software programs. So the code that is written to actually run, as I said in the previous example, the iPhone, that could be copyrightable, and that's something to consider. Dramatic, so when you think of plays, musicals, etc. So dramatic isn't just the written words necessarily for a play. It can include accompanying music. Musical, again, kind of the alternative. So if you think of songs, compositions, and musical can also include the accompanying words. Pantomimes and choreographic works. So something to think about with these, as I said before, and as we'll talk about, everything needs to be recorded in some sort of tangible form. So if you have choreography that's performed, but isn't actually recorded anywhere, then, or tabulated anywhere, then it may not be protectable with a copyright. Pictorial, graphic, and sculptural works. So photos, images, sculptures. This can also include maps, technical drawings, things like that. So it's not limited to just a photograph that you may take and publish. It can include a technical drawing. So if you have a CAD drawing or a schematic, that could also fall under this category. And then the last category, motion pictures, other audiovisual works. So videos, television shows, other recording medium like that are also protected using copyrights. So what is a copyright? A copyright is an original work of authorship that is automatically protected as soon as the author, 1, creates it, and 2, fixes it in a tangible form. So there's 3 different points in that we want to focus on when you're talking about copyrights. The first is original. So original means that it was independently created by a human author without copying. So it's your own unique work. It isn't something that you just copied from somewhere else and published in a different medium, or changed. Maybe you took text from somewhere and you changed the font and you changed the colors. That isn't original. It's independently created by a human author. Created, so there has to be a minimal degree of creativity by the author. It can't just be a list of items. It has to have an additional level of creativity above and beyond that. So for example, if you have a recipe, well, you may be able to copyright a cookbook that adds additional creativity and how to use the ingredients. A list of ingredients like flour, sugar, and butter isn't necessarily copyrightable. And it needs to be fixed. And this is one of the main requirements for copyright. So it needs to be captured in a sufficiently permanent form so that it can be viewed, copied, or communicated for more than a short time. You can think of this as kind of like a publication element to a copyright. A way to think about it is if you have a speech that you're giving and your speech is completely written down and can be reproduced, and let's say like the Gettysburg Address, for example, it can be reproduced, etc. Maybe that would have been copyrightable. If it's an impromptu speech and you're just giving it off the cuff and it wasn't recorded by anybody and it's not written down, then you won't be able to get a copyright on that. So that's kind of what a copyright is. What a copyright isn't are things that aren't fixed. So as I just said, that improvisational speech that isn't fixed in any format, that's not going to be copyrightable. Concepts, processes, short things that aren't necessarily original or creative, like a title or a short name, familiar symbols, designs, or things that aren't really original or created. They don't have that higher level of creativity. The example I gave earlier is a good one. If you have a work and you change the formatting or what it looks like, that isn't really transferring it into something that you can get a copyright on, because it's still just a copied work from somebody else that you've added on top of or altered in some way. So who can be a copyright owner? The easy answer is anybody can be a copyright owner. And If you are automatically the author and owner of a copyright once you create an original work and fix it in tangible form. So again, you have to create something that is original, not copied, and put it in some sort of tangible form. So you've taken a photograph and you can produce it. You have a recording of something that maybe musical that you've done, or you've written out the actual musical composition. You've written a poem in a format that you can reproduce it. Anyone can be a copyright owner, and it doesn't have to be limited to just one person. If you are working with somebody else on a book, for example, both of you can be copyright owners of that book. So it can be groups of people, it can just be you. The one caveat to that is, while there are certain situations, for example, works for hire is one that comes to mind, where you may be the person who's doing the actual writing, who's doing the actual work, but aren't necessarily going to be the copyright owner. A lot of times this comes up in situations where maybe you work for a company and as one of your job requirements is that you write user manuals. It's likely that in your agreement, your employment agreement, it says that while you write the user manual, you are not actually the copyright owner of that user manual. The company is going to be the copyright owner. So that's just something to keep in mind. And we'll drill into this in more detail when we talk about copyrights, but their employment agreements and work that you're doing on your own versus work that you're doing for the company are kind of things that you need to navigate depending on what the agreement covers, to make sure that if you're doing something that is really yours and truly yours, not for the company, you can still be the rightful copyright owner, and the work that the ownership wouldn't transfer to the company itself. So a little bit of history. Copyright law is set forth U.S. Constitution, Article 1, Section 8. The first Copyright Act passed in 1790. The U.S. Copyright Office, a part of the Library of Congress, was founded in 1897. Obviously, over the intervening years, copyright law has changed. For example, it used to be that you needed to register your copyright in order to have a copyright. That's no longer the case, and it hasn't been the case since March 1st, 1989. There are some other changes that have also gone into effect regarding the terms of how long a copyright lasts for, and we'll talk about those as well. So what can you do if you have a copyright? Copyright law provides an owner with exclusive rights to do several things. One, you can reproduce the work. In other words, you can make copies of it. So if you have a user manual or a textbook or some other type of presentation material, you can make additional copies of it. You can change it slightly and make different versions of the original work. So if you have a chapter, you can take portions of it and change them and reproduce them in a different format. You can distribute it, so you can give it away to others. You can sell it to people for money. You can also transfer ownership. So you can say, well, I have this copyright, it's mine, but I'm giving it to you, and I'm giving you the ability now to distribute it, reproduce it, create derivative works. You can publicly perform it. So if it's a play or music, having a copyright gives you the ability to publicly perform it or publicly display it, again, in the sense of music or art, photographs, things like that. And you can allow others to exercise any of these exclusive rights. So it's up to you to really decide who is able to use what you've copyrighted, and how and you can kind of govern how that transfer of works and what rights you give individual people. A lot of times that's governed by legal agreements that you have with the other individual, or at least something in writing that says, hey, I have this, it's copyrighted, it's mine, but I'm going to give you the ability to reproduce it. And it may be that you can reproduce it only for this limited time period or only on this particular date. So there can be a variety of requirements that are set in. how long does copyright protection last? So copyright protection lasts, the short answer is for a long time. For works created on or after January 1st, 1978, the copyright protection lasts for the life of the author plus 70 years after the author's death. If it's joint works, so if there's more than one author, the copyright lasts for 70 years after the last surviving author's death. For works made for hire or anonymous or pseudonymous other works, it's 95 years from publication or 120 years from creation, whichever is shorter. So you're going to take the shorter of the two when you're calculating it. Again, both of those are pretty long time. If it's before January 1st, 1978, there were different requirements. So there was a publication and registration requirement before then. That term was 28 years from the date of publication with notice or from the date of registration. And at the end of that 28 years, the owner had the opportunity to renew for another 67 years. So the total time prior to January 1st, 1978 that somebody could get for a copyright is 95 years. While there was that renewal requirement, that was eliminated in 1992. So it's now optional that you can renew. But the overall term is about 95 years for before January 1st, 1978. So what happens after this time period has passed? Well, after a copyright expires, the work is in the public domain and can be used by anybody without penalty. So I talked a little bit about how the law changed previously in 1989 about copyright registration. You used to need to register your copyright in order to protect it. You don't anymore. So registration is not necessary in order to put a copyright notice on something. But it is highly suggested that you go through the process of registering your copyright for a few reasons. One, if you plan to enforce your copyright at any point, it needs to be registered. So if you, for example, if you have a book and somebody takes portions of that book and is publishing them online without you giving them the authority to do so or to publish your work, you won't be able to enforce that copyright and get any sort of monetary damages from that person unless it's been registered. So you can't bring a lawsuit or enforce your copyright through litigation unless you've registered it ahead of time. And we'll talk about this in the future sessions, but the timing of that's also really important for enforcement because the infringement needs to happen after you've done the registration in order for you to get damages. There is a 3-month grace period that we can talk about, but overall, something to think about is just registration gives you the ability to enforce your rights in the copyright. It's valuable to the overall public. It lets the general public know that there is a copyright on that work. The way that it works is you will submit a version of the copyrighted material to the U.S. Copyright Office when you are going through the registration process. That ends up going into the Library of Congress. So the Library of Congress has records of everything that has ever been copyrighted. And so again, it provides kind of that record of creativity that this Library of Congress has everything. The only place that you can register for your copyright is at the U.S. Copyright Office. The registration costs, we can go, again, we'll dive into this in a little bit more detail. There are a lot of varying costs as there are for a lot of these different types of IP. They range depending on the type of work that you're trying to copyright, when you're trying to copyright it, etc. But they're all listed on the U.S. Copyright Office's website. If you're the author, you can register. If you're the owner, so if you had other individuals work on making a textbook for you as part of a work for hire, and you are the owner of the final textbook, you can seek registration for copyright, or your agent. So if there's somebody else that you authorize to do so, they can seek to register the copyright for you. The Copyright Office allows for different ways to register. You can do it online. There's also a paper application, and you need to submit the application, a deposit, and a filing fee, and have everything approved before you have your final copyright notice. And once you have that, you're able to do more to enforce your rights into copyright. So that's kind of a quick and high-level overview of copyrights. I'm going to go through trade secrets a little bit now. Again, we'll do a deeper dive in that. I think that that's our last session that we're going to do. So what is a trade secret? Well, a trade secret is kind of what it sounds like. It's commercial information that's valuable because it's kept a secret. So it's some sort of information that has value or provides a competitive advantage that's not known or readily ascertainable by competitors and is protected. So that means that you have taken reasonable efforts to make sure that it stays secret. A trade secret remains a trade secret for as long as it remains secret. There is no necessary timeline of it's only X number of years that something can remain a trade secret. And it protects a wide range of information, including things that may not be eligible for protection under patent, trademark, or copyright law. So for example, a lot of times you hear it talked about in terms of customer lists. So if you're a sales representative and you have a customer list and that's confident, that's information that's valuable, it's very valuable to your business, you don't tell other people who your customers are, you protect it, you keep that information within your business, that could be a trade secret. Trade secrets were originally a creation of state law. In 1979, in an attempt to kind of unify things, the Uniform Trade Secrets Act passed. It includes some definitions for trade secrets, how to enforce trade secrets, damages related to trade secrets. It was amended in 1985. While the Uniform Trade Secrets Act exists, that doesn't necessarily mean that all states have adopted it. The majority have adopted the Uniform Trade Secrets Act or some version of it in order to help streamline things and make it so that you have an idea of what is really governed and protected as a trade secret and how to protect it and enforce it. But there are minor changes between the states, as this was really something that was originally a creation of state law. In 2016, President Obama signed the Defend Trade Secrets Act into effect. It allows trade secret owners to sue in federal courts as opposed to just state courts when trade secrets are misappropriated or stolen or taken, assuming that your trade secret relates to a product or service that is used or intended for use in interstate or foreign commerce. So this slide has a lot of examples of what can be protected as trade secrets. I'm not going to read everything on the slide to you, but something to think about, like, so formulas can be protected, recipes, databases, customer lists, supply chain information, financial plans. When people think of trade secrets, oftentimes what they tend to think about is formulas. So like the Coca-Cola formula is one of those trade secrets that they keep protecting, that's maintained under protection. Big Mac special sauce, the KFC chicken recipe, the WD-40 formula, all of those are trade secrets that Coca-Cola knows the formula they use for Coca-Cola, but they have protected it and maintained it under lock and key, and so it's not become public knowledge. How does information stop being a trade secret? Well, the number one way that happens is disclosure. So you either purposefully disclose the information or accidentally. So maybe you don't have the necessary safeguards in place. You tell somebody the information, but you haven't entered into an agreement where they need to keep it protected. You write it down somewhere and somebody else sees it. There are different ways that can happen. The other one is reverse engineering, and this is common in technology a lot of times. So maybe you've come up with a new and inventive way of doing something, or you have a new technological improvement to a specific product. Well, if you make that product and that product is on the market, then somebody can buy it and they can maybe reverse engineer it. So they can figure out what you've done to make that product better. And if it's possible to reverse engineer it, then it's possible that they're able to your trade secret's no longer a trade secret because it's been figured out publicly. The same thing can happen if somebody comes up with the same thing. So you have a trade secret on your device or process, but if somebody else files for a patent on the same thing and that enters the public domain, then it's not really your trade secret anymore because the public's already aware of what it is as it was patented by somebody else. Same with researching the same topic or developing the same lists or methods. If somebody is able to achieve the same end result as you, even if you had it as a trade secret, once it becomes public, it's no longer your trade secret. So how do you protect trade secrets? There's a couple of different ways. You can use physical security, so secure rooms, locked cabinets, locked rooms, limiting access, so only people who are allowed to see the information can get into it. Digital security, passwords, firewalls, restricted use. So even if you have a large company, maybe everybody who works there doesn't need to have access to the trade secret information. So you can limit the number of people who have it, which reduces the potential that it may be made public at some point. And there's also legal measures. So a lot of times you have confidentiality agreements, non-compete agreements that you have with employees, and non-disclosure agreements. So non-disclosure agreements are often in place and are used when you're working on something that's trade secret material information, you're protecting it. Maybe at some point you plan to do more and you may file for a patent, maybe you're not quite there yet, but you can create a non-disclosure agreement that you can use that governs and protects any information that you exchange between yourself and the other party during your work together. Something to think about and keep in mind for trade secrets is to avoid any sort of narrowly tailored sunset clauses about timing. So for example, you don't necessarily want to say, hey, you need to protect this confidential information for 2 years, because what if it's still one of your trade secrets? 3 years from now, they may say, well, we're not under any obligation after that. And there's some legal issues associated with that, but it's just generally good to keep in mind that you don't necessarily want to time limit those agreements. Employment agreements, oftentimes companies have very explicit rules about who can access proprietary information, how it can be accessed, how and what you can do on company computers, with company information, company printers, so shred bins, things like that. Additionally, explicit mention of non-compete. So you can't take the information that you gain as confidential information from company A, leave, 2 months later go and work at company B and tell them all of the secrets that you learned from the first company. A lot of times, this is also a good place to have employee training and just have very clear operating procedures in place. So that was kind of a high-level overview of copyrights and trade secrets. Again, we'll do a deeper dive. I don't know if now's a good time to stop for any questions that we may have before I turn it over to Lee to talk a little bit more about trademarks and some patent issues.
We just have a couple of questions on trade secrets.
Sure.
You mentioned that trade secrets stay trade secrets so long as they are not publicly disclosed or somebody kind of finds it out the backwards way. Other than those two limitations, is there a time limit on trade secret protection?
So in theory, no. There is no time limit on trade secret protection per se, but I will say that if for trade secrets, it's kind of a how long are you going to be able to keep it as that secret? So for example, Coca-Cola has kept their formula trade secret for a very long time. But depending on the work you're doing or the procedures that are in place, it's possible that somebody may come up with it in the meantime, and kind of create an artificial timeline. So I think that a lot of times it's kind of knowing what your technology is to figure out whether it's something that you may be able to protect as a trade secret indefinitely, or if maybe you should seek some other form of protection for it to make sure that it doesn't get discovered in some other way.
Okay. You keep talking about, kind of using trade secrets as an interim strategy, or maybe long-term, but as you just mentioned, that's less sustainable. Would you recommend that a business that thinks they may have valuable intellectual property that could be trademarked or could be patented, treat it as a trade secret until they seek advice or take next steps to protect it under other areas of law?
I think that that's the best plan. I think in general, if you're planning on seeking some other type of intellectual property on it, and if it's something that you think is proprietary and that is really helpful for your business, the best way to go about it is really try to maintain everything as confidential. And I think that kind of applies across the board in terms of business strategy and just general dealings with others. I'm not saying don't ever tell other people that you need to in company meetings, joint development, research agreements, et cetera, what you're working on, but just make sure you have the necessary protocols in place to ensure that you are adequately protecting it so that if you want to seek protections for it down the road, you can.
Perfect. Thank you, Kate.
Thanks. And so I will hand it over to you now, Lee, to talk more about trademarks.
Thank you, Kate, and thank you everyone for being here. And also thanks DC Bar for giving us the opportunity to present it to you. So I will talk about trademarks and some of the patent related issues. So first, what is a trademark, right? A trademark is also a type of intellectual property that identifies the source of the products or the services. It can be a lot of things. For example, it can be a word, a phrase, a symbol, design, or a combination of them. In addition to identifying the source, trademark also provides legal protection of your brand and can help you guard against counterfeiting and fraud. Sorry. We see trademark every day. I mean, they are everywhere. For example, you can see brand names like Apple or McDonald's, and product names like iPod or the Big Mac. And we see also company logos, for example, on the screen, that's the golden arches at the McDonald's. And you see like Nike's swoosh, and you also see additional standard character examples such as Coca-Cola or Twitter or America runs on Dunkin'. So a trademark really can be so many different things and forms, and it's very important to business to have their trademarks protected. So we're going to talk about the categories of trademarks because in order to distinguish the goods of one of yours from the others and to function as a trademark, the word, phrase, or design or symbol, they must be distinctive. Generally, trademarks can be put into different categories of distinctiveness. For example, the top one is called fanciful marks. They're at the top of the scale in terms of the trademark strength. The words in these categories, they have no other meaning at all apart from its association with the product or service. They're just purely invented words. For example, Kodak, Starbucks, or Exxon, Clorox, like those words didn't exist before people were using those terms as a trademark to identify their products. And the second category of the trademarks is called arbitrary trademarks. And these marks, they're familiar words, but they're used in connection with unrelated products or services. For example, we use Apple to identify computers, and we use like Monster for the job searching, and like Banana Republic for clothing. So these terms They have no connection with the products or services they describe, but they are used as a trademark to identify the source of the products. So they're also very strong marks. And the next category is called suggestive marks. And suggestive marks, they're not as distinctive as the first two categories, but they can still be considered as strong marks. Okay, what is a suggestive trademark? So a suggestive trademark, it hints at some function or property of the product or service, but they don't directly describe that. So suggestive marks, they often use words that embody some characteristics associated with the products or service. For example, here I have an example here. It's called physician's formula for skin cream, or Airbus for the airplanes. And like we also know, for example, Greyhound is used for bus services. So those are suggestive trademarks. The next category of the trademark is called descriptive mark. So descriptive marks, they are the weakest marks among these categories. It usually is a word or design that directly describes the product or service. For example, call if you're selling yogurt and if you call it creamy, that's pretty descriptive. It's only registrable after gaining distinctiveness through extensive use in commerce for many years, and it's very difficult to register a descriptive trademark. Some examples of descriptive marks including Vision World. It is a registered trademark for optical store services. The final it's the generic trademarks. They're actually not trademarks because you can never register a generic term for trademark. They are they are just common everyday names for the goods and the services. Therefore, you cannot use that term exclusively to identify the source, and they cannot function as trademarks, and they're not registrable. For example, if you're selling bicycles, you cannot register your store as bicycles because other people need to use that term to describe their products of bicycles as well. So how do you acquire rights in trademarks? And assuming that a trademark qualifies for protection, the rights to a trademark can typically be acquired in one of the two ways. One is by being the first to use the mark in commerce, and or two, you can register the mark with the U.S. Patent and Trademark Office. If you don't register your mark, you get common law rights from the actual use of the mark, even if you don't register that. Although registration is not a requirement for trademark protection, unlike a copyright, like Kate discussed, registration does provide important benefits, and therefore it is recommended. For benefits of a federally registered trademark, they can include uh, filing a trademark lawsuit in federal courts, and you can get enhanced damages if other people are infringing your trademark. It also has geographic coverage for the entire nation instead of a local area. After 5 years of using the registered trademark continuously, it becomes incontestable. So it's immune from challenge, except if the mark, becomes generic itself, or it's abandoned or not used, or if the registration was acquired under like fraudulent conditions. Other than it become incontestable. The one thing I didn't mention on the slide is that you can also register a trademark with the state, but the state trademark registration, even though it is like probably less expensive, or you can get it faster, but generally if you want to register a trademark, a federal registration is recommended. So a common law trademark is obtained simply by using the trademark in association with a business or product. And you can use the symbol that's the TM in a circle. So using a TM as in a common law trademark kind of puts others on notice that the words or symbols are used as a trademark even though it is unregistered. It is still enforceable mark and can be used on the products and services. It does not give you the right to prevent new business in other states from operating under the same name as yours because common law trademark has geographic restrictions. It does not give you nationwide protection of it. In contrast to that, the federal trademark gives you the rights of the nationwide protection, and you do have to file a trademark application with the U.S. Patent Office, and you need to get approval from the Patent Office to get a federal trademark rights. That puts others on notice because there is a public record of your federally registered trademark. It gives you the ability to file a lawsuit in the federal court if others are using and infringing your trademark. You can also use the R symbol that indicates the trademark is registered with the USPTO. I briefly mentioned before that even though it's not on the slides, you can register your trademark with the state, but a state trademark registration does not give you the right to use the R symbol. You can use the TM symbol for state trademark registration, and as I mentioned, it only protects your trademark in the state where you register that. So even though it's a little less expensive, probably you can get it a little faster, but if you register a trademark, if you go through the process, it's more beneficial to do a federal trademark registration. So before choosing your mark, it is very important to do a searching to make sure that the brand name you're going to use is not already used by other people. And you can do some preliminary research by yourself. For example, the federal trademark registration has a database on the PTO website, and the state trademark registration usually also have a database in the state, and you can search business name directories or domain name registries and like media databases and whichever industry of your products, you can do industry specific resources search. One note is that if you plan to use the mark outside of the United States, you probably want to conduct some foreign availability search of the trademark to see if the trademark you're going to use is already used in the country that you plan to sell your goods or services. One thing I want to mention about domain name registry, because as of now, we know if you have a company, people kind of expect you have the same website name for your company. So that's something to consider when you choose a name, whether the name is already a domain name used by other people, because then you cannot use the same domain name for your own business, which people nowadays expect you to have the same domain name as your company name or your trademark name. So it's good to do the search of the domain names as well. And just to summarize about how to protect your trademark, first of all, to choose a strong mark, especially like we discussed the first two categories, either a fanciful trademark or an arbitrary trademark, and don't use a generic trademark or don't even use a descriptive trademark because it's very difficult to get it registered. And try to do a comprehensive trademark search to make sure that your mark is not already used by other people. You can do a preliminary search by yourself, but you can also hire a trademark attorney to do a more thorough search for you. And make sure you register trademark with the USPTO and police your mark. Also consider international registration if you plan to sell your products or goods in other countries. and maintain your mark. And even though trademark does not expire every 10 years, you're required to renew your trademark with the patent and trademark office if it's registered. So I'll briefly talk about the patents. I think as Kate mentioned before, we're going to have a section on patent for the next webinar. So we're going to go into much more details in our next webinar, and I'll just briefly introduce the patents at a high level here. So patent is an exclusive right granted for an invention. It gives you the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. It has a limited term of 20 years, and similar to the trademarks, it is territorial. There's no worldwide patent. So if you want to have your invention protected in other countries, you need to file the patent applications in the other countries as well. And why applying for a patent, right? So the patent, as we discussed, it exclude others from copying your invention. And one of the important things nowadays is if you seek funding from investors, if you present your idea to them, one question they often ask is, as we see from like the TV show Shark Tank, right? If you're saying, hey, I have a great idea for this company, they often ask, do you have a patent for this idea? Because that will give you and your company exclusive rights to that invention. It also can potentially generate a revenue for you because you can license your patent to other companies. If it's a technology essential to the industry and they will need to license your technology and they need to pay for a license fee for your invention. You can also cross-license with other companies. For example, they have a patent on something else, you have a patent on this, and they need your patent, you need their patent. You can cross-license each other's patents. Also, like when you sell your company, patents, they are properties and they can add value to your company. There are three types of patents. The utility patents are the most common, and the design patents also, they're becoming kind of more important now. And the plant patents, you can also get a plant patents, but there are not that many of the plant patents. So for utility patents, it's pretty much anything that is new and useful. It can be a machine, it can be a process, it can be an article, it can be a composition of matter, and any new and useful improvements can be filed as a utility patent. So for the design patents protect the ornamental features of a product. I have some examples here. For example, the Crocs, the Coca-Cola bottle, the the iPhone or the staircase, and a lot of products. If their features are ornamental, you can apply for a design patent. So plant patents, it covers the plant that's new. If you invent a distinct and new variety of plant, you can apply for plant patents. So here I have some recent examples. People obtained plant patents for a new type of Keller lily plant and a new type of strawberry plant. And one question is like, how do you know if your invention is patentable? One term you're going to hear very often during a patent application process is called prior art. That means what information is available when you are filing your patent, because the publicly available information will be used to evaluate whether you can get your patent. Information including patents, publications, and other information available nowadays on the internet, because the examiner is going to do a search comparing your invention to the other information already available at the time of your filing to see whether there's anything new and not obvious that can give you the right to that specific invention that will exclude others to use it for 20 years. The next question is like, should you file a patent? Because a patent can be quite expensive comparing to some other types of filings, because trademark is only a couple $100. For patents, you typically will need an attorney because it has very specific requirements. It will have like a filing fee, examination fee, allowance fee, and the maintenance fee. For the 20 years, you have to pay maintenance fee at different time through those 20 years. So to decide whether to file a patent, you need to conduct a cost and benefit analysis. How much benefit is the patent is going to give you compared to the cost you need to spend to get the patent and maintain the patent and maybe enforce the patent. And also consider the shelf life of the product. If the changes in the technology are very fast, if the patent you're applying this year will not be applicable anymore to the product next year, then you may not want to spend the money to apply for a patent. And also think about how the patent will be used. Like, are you going to use it on your products? Is the main purpose is to exclude a competitor, or are you going to license the technology to other people? And also think about whether the technology can be used outside your market. If it can, that can add value to the invention you have. Also determine patentability. You can also do a quick search. There's a patent database at the PTO, and you can do a Google search to see whether your idea was already patented or was already publicly available. So before you file your patent, because that will prevent you from getting the patent. And also think about the workarounds for the patent. So if you have an invention, and even if you get a patent, if other people can easily design around your invention, then that may impact the value of your patent. And when to file a patent application? There are good reasons to file them early, because public disclosure, public use, or the offer for sale of the technology can cause you to lose your right to patent, because those information will become prior art. And if you're going to pitch to investors, think about filing the patent before your pitch, because they're going to ask you, hey, do you have a patent, or do you have a patent pending for the technology? Also, the first to file rule will give you an early priority date if you file the patent early. There are also good reasons to wait, because the cost is very high. You want to wait until your product, your idea is further developed before you spend all the money to file for the patent application. How much does it cost to get a patent? Like we discussed, it can be quite expensive. Typically, you will need an attorney to do the patent application and filing and responding to the office actions from the examiners. That can depend on the attorneys you use, and also the fees at the PTO, including filing fee, examination fee, allowance fee, maintenance fee to keep the patent. The process of patent application, you think about what type of patents you need, and work with the patent examiner to get the patent, and also pay the maintenance fee. Okay, that's my part of the presentation. So Christine, I don't know if we have time for questions, or if we should go to Kate to finish the presentation.
I will go quickly too. So because we're doing a deeper dive on patents next time. So I just wanted to talk quickly now and preview kind of how you have a patent. What do you do with it now? So patents kind of give you the ability to enforce your rights and prevent others from doing what you've claimed is your invention. Patents don't actually give you the right to practice your patent. It just really gives you the right to prevent others from doing what you have patented. So the right to exclude others from kind of stepping on your invention. What does that mean for a party to infringe? Well, a party infringes when they make, use, or sell your invention in the United States, or induce or contribute to the infringement of your patent without your authorization. So inducement and contributory infringement are kind of indirect infringement. So maybe the other party isn't themselves doing it, but they are helping, they're providing components to the company that ends up actually doing the infringement. They're providing parts and instructions to an end user, and then your end user is the person who actually infringes the patent when they set something up or they perform the method. And we'll talk more about the different types of infringement in the next session. So if you think that somebody is infringing your patent, what can you do? You can file cease and desist, you can send cease and desist letters. So you can send that person a letter that says, hey, I have a patent on this and you need to stop doing what you're doing because you're infringing my patent. You can file a patent litigation lawsuit. So you can bring a lawsuit against them asserting your rights and saying, here's my patent and here's why I think that this other person is infringing. The other option, if you don't want to do litigation or if they haven't responded and you just want to maybe get money from it, is you can license your rights. So you can say, hey, I think you're doing what I already invented, but I'll give you a license so that you can keep doing it and I won't actually sue you and you can just pay me X amount of money, to be structured in a lot of different ways, to use my patent. So how do you track infringement? So a lot of times, this isn't a one-size-fits-all solution. The best way to do it is to really monitor competition. A lot of times you can do that by going to industry events, trade shows, conferences, seeing what others are doing in the field and industry gives you an idea of two things. One, making sure that somebody else isn't infringing on your patent rights. And it also gives you an idea of what other people are doing. So you can make sure that as you're developing your product, as Lee talked about with design arounds, that you make sure to design it in such a way that you don't necessarily step into somebody else's patent rights. You can also follow other companies' patent portfolios. If there's this particular company that you're really concerned about, that may be one way of making sure that you don't end up infringing one of their patents. And also figuring out if there's a way to enforce your rights. And again, this is just kind of a very quick high-level overview, but we'll talk more about how you apply for a patent and how you enforce your patents once you have them in the next session. So I think if we have time for a question or so now, maybe we can do that now before we finish up.
All right. So, kind of one last wrap-up question that touches on everything. Both of you mentioned state law, federal law, international registration. So when it all comes together, these intellectual property protections that we started getting into today, do they only cover the United States?
For the trademark and patents, that if you file your registration with the USPTO, they only cover the United States. For patent, though, you can file that through a route called the PCT, and after a certain amount of time, you can choose different countries to continue your patent application. That could include United States, like Europe, and other countries.
Great.
And for copyrights, again, kind of like with trademarks and patents, but a little bit different. So in general, US copyrights are generally only for the US, but the United States has entered into international agreements with other countries. So it's possible that a US work will also receive copyright protection in another country if that country has an international agreement with the United States about protecting copyrights. So thank you everyone who attended today. We really appreciate it, and we look forward to kind of doing a deeper dive into patents next time.
Yeah,
thank you.
Thank you both, Kate and Lee. And thank you to everyone again for joining. We'll send out a survey, so let us know, what information you found useful. And once you fill out that survey, you'll also get a recording of today's program. We hope that you'll join us on July 21st. As Kate mentioned, we'll dive into patents there. So really getting into some more details and how it may benefit your organization. And remember, if you would like to speak one-on-one with an attorney for free about your organization's legal needs, view the Pro Bono Center's upcoming events, or check out our online resource library, you can visit us at lawhelp.org/DC/NPSB, lawhelp.org/DC/NPSB. DC/NPSB for nonprofit and small business. And one last time, thank you so much again to Kate, Lee, and the Steptoe & Johnson team for today's presentation and for working with us on this fantastic intellectual property series.